All right, we're going to see how this works. I am now running a YouTube Live version of this update simultaneously with a Facebook Live update. So if I have any streaming issues at all, because my bandwidth cannot handle it, I will probably end up closing out of the Facebook streaming and going over to the YouTube streaming. So just to clarify, if I have any kind of streaming issues at all, I will likely close out of the Facebook Live and go over or continue to stream with the YouTube Live version, which is on this other camera here. So that's because Facebook is being done on my phone and YouTube is being done on the computer. So now keep in mind, I'm going to do my best to keep up with questions and comments, but quite honestly, my Facebook friends, if you can actually try to join me on YouTube Live instead, it's going to be far easier for me to keep track of the chats, just given how YouTube Studio works. So if you can join us over there, and that way, whatever questions and comments, it's far easier for me to keep up with them, albeit it'll be a challenge because there'll undoubtedly be a lot of comments and questions. The more of you that can, in fact, come on over to the YouTube side of things, that would be greatly appreciated. I'm going to have a bit of a difficulty seeing the comments and questions on my phone on the Facebook Live version right now. But with that being said, I'm going to go ahead and get rolling here. So for those of you who might not know me, I would think by now, if you're watching, you know who I am. But in case you don't, I am constitutional attorney Catherine Henry, and I'm here to give you an update on two different Supreme Court cases that came down just a little over an hour or so ago. So let's see, which one do I want to handle first? So I guess the first one that I will handle is court file number 161492. That you will, first of all, the reason why I give you court file numbers is because if you go to the Michigan Supreme Court's website, I haven't checked it recently, but I am almost confident that they will have on there, right on the main webpage, a link to these most recent orders because they are a public interest type of order. If not, or if you can't find it on there, we actually did also put it on restorefreedomkh.com, restorefreedom, K as in Catherine, H as in Henry.com, and you can go to the resources tab and you'll be able to find both of these court orders there. Okay. Someone, by the way, is saying that they started out on Facebook Live and the audio is way better on the YouTube version. So for those of you, my 309 friends and growing, that 317 friends and growing that are on, okay, a lot of growing. All right, guys, those of you on Facebook, if you can at all, get over to the YouTube side instead. From what I'm hearing, the audio is a lot better over there, and my ability to keep up on questions will be a lot better. Not that you can't stay on the Facebook side, but if you're able to, please do check us out on the YouTube side. With all that Facebook has been doing recently, I'm going to do more and more on YouTube than to rely on the Facebook side of things. So with that being said, I'm going to go, like I said, with the court order on court file 161492. The court order itself is actually very short. What it says is, and I guess let me back up and say, the motion before the court, the motion this court is addressing in this order, is whether the governor is allowed to have a she actually asked for a 28-day extension from October 2nd, when the Michigan Supreme Court issued their decision, all the way through October 30th, so that, you know what, guys, I actually should grab the, the motions. I don't have the original files in front of me. Give me just 1 second here. I guess I don't have that. Emma, they're in there. There's a whole bunch of binders. Can you hand me the blue skinny ones, please? Behind that door. Okay, so while my 6-year-old legal assistant is working on helping me with that, basically what the governor did is she was asking for that time because, as you know, on October 2nd, the court came out and said the number one, the Emergency Management Act of 1976, they did not address whether that law violated the state constitution. What they did address is the fact that the governor did violate the Emergency Management Act of 1976 by continuing to issue orders after April 30th. Nope, a different one, baby. Sorry. And so the second question that they addressed was whether the EPGA, the 1945 law, whether that violates the state constitution, specifically the separation of powers clause or the non-delegation clause. Let me see which one you got, baby girl. What the court said is, yes, the EPGA, the 1945 law, is inherently unconstitutional. Let me see. Nope, different one. Sorry, baby. One more try. It's on the top shelf. Nope, the one in the middle. Yep. Sorry, guys. It is kind of blue, isn't it?
No, it's mostly black.
Yeah, it's blue, dude. It's just dark blue. Okay. I guess we're still learning colors here today. All right, thank you, Ems. Okay, so in this case, like I said, we know what the court did. The governor came out that Friday and said, well, okay, so the court said this, but I have 21 days at least for my executive orders to continue to have full force and effect of law. That's not true. It never was. She had that as a scare tactic and, quite frankly, as a bald-faced lie. And it's amazing how many different stores and business owners and restaurants and everything that I've gone into since that time have said, "Oh no, I still have to have the signs on my door because the executive order it's still in place for at least 21 days." Of course, I've had fun educating them about that because that's not at all the case. So what the governor did, though, she is a licensed attorney, keep in mind, so she should know these things. At least know how to not speak with her foot in her mouth before she looks them up. But she ended up filing last Monday a motion with the Supreme Court saying, well, you know what, I would like you to wait on giving those orders effect or giving those opinions effect right now. I want you to give me 28 days to do so. So that would be the October 30th. So she's... that was the request she made in the case with the 3 doctors' offices and the 1 patient that were suing her and the Attorney General and the Michigan Director of the Department of Health and Human Services, Robert Gordon. So with that being said, that was filed on a Monday. The governor also filed a motion for immediate consideration saying, hey, listen, this is super important. The court needs to hear this right away and not wait the traditional amount of days to issue a decision in this case. The legislature then filed their reply to that, or their response to the motion, on Tuesday. Now keep in mind, they were just an amicus participant, just the same as I was. And the real plaintiff in that case also filed their response to the motion on Tuesday. And the Attorney General did not file then until Friday morning around 11:25 a.m. I then filed my response also on Friday and essentially argued a few points, but I can come back to that. Now that you know the context, the order is literally only 2 sentences long that came out today on this case. It says that on the order of the court, the motion for the immediate consideration is granted. Okay, so they're going to hurry up and decide this right away. And the motion to stay the precedential effect of the October 2nd, 2020 opinion is considered and it is denied. So they're saying that the governor's request is denied. So she will not get the 28 days that she was asking for. She's going to get no additional days. In fact, the way that the court rules read, the way that the precedent reads in this situation is that the moment the date stamp goes on the court's order, the court's opinion in that case, it has precedential effect, meaning if they say something is unconstitutional at 3:00 p.m. on, in this case, I think it was right before 5 o'clock on Friday, October 2nd, that means at 5 o'clock, Friday, October 2nd, that's when the unconstitutional label gets put on there and she can no longer use that. What sense would it make in any world, regardless of if you're a Republican or a Democrat, if there's something unconstitutional for the person who was implementing the unconstitutional procedures to be able to continue acting in an unconstitutional fashion? That makes no sense. Why have any basis of government at all if we're going to say, yes, we know that you're breaking our very foundations and structure and limitations on government, but we'll go ahead and allow you to continue doing so because it's just more convenient that way. Unfortunately, we do have some justices that were arguing for that. But in this case, luckily, that is not the argument that won out. So just so that you are aware, Chief Justice Bridget McCormick, one of the justices who's up for election, she actually concurred with the main agreement in this case, or with the main decision in this order. So that means she's agreeing with it, but she's kind of explaining it for her own reasons. And she doesn't agree with the underlying decision that the EPGA is unconstitutional, but given that the majority of the court has spoken on that, she does not believe that there should be a delay in that at all. And she believes that for a couple different reasons. One of them, she points out that the court rules do not provide a way for any party to the lawsuit in the district court to challenge our answer in this court. And that's correct. That's what I've been saying to people. And it's interesting that she notes in here that there's just some pieces of the court rule that I guess that she's noting. Now, just so you know, Justice Kavanaugh joins in the the concurring statement of Bridget McCormick. Justice Bernstein, however, has dissented. So what does that mean? That means that 6 of these justices agreed with the outcome, which is that the unconstitutional declaration about the 1945 law and the fact that the governor violated the EMA, meaning that she has zero basis of law or no constitutional authority to continue to act under her executive orders, that declaration from the court is going to be immediately effective as of October 2nd. 6 of our justices agreed with that. Only Justice Bernstein said, no, I think we should wait until October 30th to allow her more time. In fact, what he says here is, I agree with the defendants, meaning the governor and the Michigan Department of Health and Human Services and the Attorney General. I agree with them that delaying the effect could only allow the governor and the legislature the time to better prepare for an immediate, I can't even read today, that delaying this would allow the governor and the legislature the time to better prepare for an appropriate transition. And then he talks about Executive Order 2020-76, which relates to the unemployment. The thing is here, though, the matter of convenience, the matter of whether it's wise or not, or whether there's a better way to do it, is not at all relevant. When it comes to an issue of something is unconstitutional, that's the question. Is it unconstitutional? If it is unconstitutional, then the government has no authority to continue to act in that regard at all. Zero, zilch. So if you don't have the ability to act in that regard, why should you get a delay to continue acting in that regard just to work it out with another branch of government? Because whatever fix they put in place might not necessarily be constitutional either. In fact, if we look at their biggest claim to fame on trying to work it out with the governor, that would be Senate Bill 858, which as it was introduced, Senator Tom Barrett simply said that we should reduce the number of days in the EMA from 28 down to 14. As it got voted on through the House of Representatives, though, it came back an entirely different bill, entirely different. It was back up to a 28-day limitation on the governor, not 14. And it codified 29 of her executive orders that were in place at the time. It covered a variety of subjects in violation of our state constitution. It was just an entirely different bill. So our governor was actually correct that night when she said in a press conference that she was going to to veto Senate Bill 858 because it was unconstitutional. That was actually what she had to do. So more power to you, Gretchen. Wait, not literally. We're not actually trying to give you more power. You only get what you get. So there's a couple of important things to point out too, with that order being said. Oh, you know what? I totally forgot to put my phone on silent. Isn't that great? Sorry, guys, especially in the Facebook world. Let me see if I can quick do that for you guys. Okay, there we go. Nobody should bother us anymore on that. So I filed my brief, like I said, with the Michigan Supreme Court also on Friday. Not my brief, excuse me, my response to the governor's motion. And I put a lot of information in there. Quite frankly, I know what the issue is that was properly in front of the court. And that issue was specifically limited to whether the court is supposed to give immediate effect to the opinion that they released on October 2nd, or whether they were supposed to wait somewhere between 21 and 28 days. That was the question before the court. However, the reason the governor gave was because the governor wanted to, and the director of the Department of Health and Human Services, let me see, I will find it for you here. The governor and the director seek to ensure that some responsive measures can be placed executive authority. That's what they declared in their motion for immediate consideration. Alternative executive authority. So, yeah, okay, it might be nice and fine and dandy to have the governor work with the legislature and try to, find some resolution. But it's been very clear and very obvious right from the beginning, the governor's going to do whatever she wants to do, and she doesn't think she answers to the people of the state of Michigan. That's why she makes a mockery of petitions. She doesn't think that she has any kind of balancing she has to do with the Supreme Court, the judicial branch, or the legislature. She also doesn't think that constitutional limitations have any application to her at all. So the main thrust behind the striking down of the EPGA is, again, the question was very narrow. The question that came from the federal district court was not whether these executive orders or whether the 1945 law was unconstitutional because it violated our constitutionally protected freedoms. The question should have been that. In fact, I strongly believe the justices have an obligation to always consider that. But rather, the question itself was whether the 1945 law violated the state constitution, specifically just the separation of powers clause or the non-delegation clause. So with that being said, it's just important that we realize, oh, how do I want to word this? The governor is implementing these other tools, right? She has said in a variety of ways that she's going to be using whatever tools she has at her disposal, that she's going to, of course, my son is calling me now on my phone. That's my birthday boy. He will be 17 in a few days. So at any rate, the governor said she's going to be using these other tools. Primarily, she's going to be using the public health code until she digs out something else that's in our laws that needs to be struck down. But she's been utilizing mostly Chapter 333, and that would be MCL 333.2253 and 333.2453. So if you have been sending me any requests at all for information on, say, the local health department issuing their own orders, requiring you to wear masks or requiring you to stay in your homes, or do any kind, limit the capacity in your restaurant, or, to be socially distant, or whatever the case is, right? To not be able to gather in any kind of groups of more than 2 with people outside of your own household. Those things are done under MCL 333.2453. That's the local health department version. The state health department version is 333.2253. And in any event, the statutes themselves are not constitutional for the same reason that the EPGA from 1945 is not constitutional, but also the health departments, whether it be the local or the state, they're not following the language of the statute itself. So those are some very important points to make. And I'm going to go over that in just a minute, but I just wanted to explain to you, the court didn't address that. They didn't specifically address those statutes in the original opinion that came out on Friday, October 2nd. And they did not address that in the order today, because the order today was very limited and addressing just when does that opinion take effect. And the court was very clear in their 2 sentences of the order that the opinion takes effect October 2nd. The motion to extend it beyond that time is denied outright. So just to be clear, in case anybody's wondering out there, and I will get 4,000 questions of the same, basically the same thing. Is this order still in effect for 21 days? What about the 21 days the governor says she has? Where does that come from? So as to the governor's executive orders, they were done October 2nd, period. No matter what she says, they were done. As far as these other orders, we'll kind of go over that in just a minute as well. But the governor herself opened up the door to talking about having this alternative executive authority. And that's why I kind of wanted to plant the seed that we need to look into that a little bit more and realize that it's not that the court is saying anything positive about this alternative executive authority. It's that the court hasn't said anything at all about it, which is a totally different thing, and we'll cover that in a second. So before we do that, though, I wanted to make sure to let you know, in the other case, which is 1617, I can't read at all today, 161917. Now, that is the one that most people think that this case has all been about. That is the legislature's lawsuit against the governor. So before the legislature's lawsuit, before October 2nd, the legislature had filed their appeal in the Michigan Supreme Court to appeal what happened in the Michigan Court of Appeals on August 21st. And they said, you know what? They got it wrong. We're going to ask that you take this case, that you take this case fairly quickly. And the Michigan Supreme Court, of course, held off for now and didn't do anything in that regard. After this decision came out, the legislature filed some requests in the Michigan Supreme Court on their own case, which is the 161917 case. They requested with the court that the court issue what's called a peremptory reversal. Okay, so that the court get rid of, basically undo what the Court of Appeals did based on the opinion that came out on Friday, October 2nd in the other case. So basically using the other case's result to do something different in their own case. So it was one way of trying to attack the issue, I guess, if you will. So what the court said in that case, that's a little bit longer. There's maybe, I don't know, 5 sentences, 7 sentences, something like that. So I'll just go ahead and tell you what it says. This is also available. It should probably be available on the court's website, like I said, but it is available on restorefreedomkh.com. Restore Freedom K is in Catherine, H is in Henry.com. And you'll be able to look at the resources tab and find it there. So on order of the court, the motions for immediate consideration are granted. So they're going to go ahead and issue a decision based on all those pending motions immediately. The motion for peremptory reversal is considered, and for the reasons stated in this court's decision in the other case, it is granted. So the court granted the legislature's motion to reverse the Court of Appeals, essentially without having another hearing, without having any additional oral arguments, without having any additional briefing. They did, I believe they filed a brief in support of their peremptory reversal. You know, there were a few responses, I believe, to that. Of course, the main focus was on the underlying issue where we had oral argument heard in the other case. But the court continues to say that we reverse the part of the judgment of the Court of Appeals holding that the governor possesses the authority to issue executive orders under the EPGA, as stated in the In Re Certified Questions case. So as stated in the other case, the one we just talked about, the EPGA is incompatible with the Constitution of our state, and therefore executive orders issued under that act are of no continuing legal effect. No continuing legal effect whatsoever. So just in case the governor tries to say anything else about how, no, we're good. I get to actually continue this under this case instead of that case. They very clearly say that the executive orders issued under the EPGA are of no continuing legal effect. This order right here is effective upon entry. What does that mean? Now, immediately. So the fact that it is entered, the fact that it has been shared with those of us attorneys, it's effective. So that means in either case, basically both cases recognize that the governor's executive orders, they're done. They also reference a court rule, and then they say we remand this case to the Court of Claims. Remember, that is the trial level version of court when you sue the governor for something like this. That was that hearing that was held, I want to say it was May 21st. That's when that hearing was held. So the Supreme Court is remanding all the way down to the trial court, then to the Court of Claims, for immediate entry of an order granting declaratory relief consistent with this order. So whatever that looks like, I don't know. That's not specifically stated here by the Michigan Supreme Court. But then they do add that it should again be emphasized, as they pointed out in the other case, that our decision today, like our decision in this other case, leaves open many avenues for our governor and legislature to work together in a cooperative spirit and constitutional manner to respond to the COVID-19 pandemic. So cooperative, definitely a plus. Constitutional, it's a necessity. She can't do anything. They can't do anything together unless it's constitutional. They could agree 100% that they want to do something. She could have agreed that she wanted to sign Senate Bill 858. And I wonder if in hindsight, she's not regretting that decision right now. But the problem is that bill is unconstitutional in a variety of ways. So even if they agree on doing something, it still has to be constitutional. Even if a large majority of the people out there are going to come out and give more, death threats to me and and all kinds of awful emails and calls and text messages, and contact me on social media and tell me what an awful human being I am and I should be disbarred because I've told people that they should burn their masks. Let me tell you this: if you want to wear a mask, you are allowed to wear a mask. If you don't want to wear a mask, you don't have to wear a mask. But we have the freedom to choose those kinds of things. If we want to breathe fresh air here in the United States of America, we have the right to do so. So with that being said, those are the two orders that came out from the court. Now, I wanted to kind of go over a couple of, I guess you could say, kind of more key points about this. So just to reiterate, the governor's executive orders are what the court has ruled on specifically. Just the governor's executive orders. And the governor's executive orders, zilch, zero, not have any force and effect at all after April 30th. They did not come out and say that the governor's executive orders were in fact legally and constitutionally enforceable before then, because they did not address the question of whether the EMA was also unconstitutional. Because if the EMA, the 1976 Act, is unconstitutional, which as an attorney, I'm telling you that it is unconstitutional. But if it's unconstitutional, then again, whether she's relying on the EMA or the EPGA, with both being unconstitutional, then she would have zero basis in law to be able to create these orders in the first place. So the court did not say that she was totally fine and legal and constitutional with her executive orders between March and the end of April. What they did say is, we're going to start asking or answering the question after April 30th, was there a problem? Yes, there was. She had no statutory authority. So, so they said that, and again, the 1945 law is entirely unconstitutional. What does that mean? Governor Whitmer can never, ever again utilize the 1945 law. What does that mean for future governors? They can never, ever again use the 1945 law. Now, what if it's about a flood? Or it's about, COVID-19 comes back, but it's like 3 years from now and it's a different strain. Or what if there's a zombie apocalypse, right? Anything. No governor can ever use the 1945 EPGA period ever again. Never, ever, ever. So for those people that have been out there claiming that, well, we still have to get it repealed. No, don't get me wrong. I think all unconstitutional laws need to be taken off the books. Absolutely. And the court has made itself very clear that is not the place of the court to do so. The court's not going to, traipse on over to the legislature, take a big eraser to the law books, and then erase laws that are on the books. No, they expect the legislature to do their job and clean up the statutes so that no unconstitutional laws are left on the books. However, that hasn't happened. For example, let's look at 2018. In 2018, we had some changes to our state constitution that were voted on in November, right? I voted against all of them, but nonetheless, they're on there. They're part of our state constitution. So in the process of doing that, the group that was Voters Not Politicians, they were challenged by Citizens Protecting Michigan's Constitution. That challenge ended up in the I believe it was the Michigan Supreme Court. And the court, at any rate, along the way, in that case or a related case, there was a declaration that some new laws that have been put into place recently regarding when you do petitions, you have to, the law had said you have to do it by county, right? So you have to have a signature sheet where you have everybody's name on there, but everybody has to be from the same county. Well, the new law said it has to be by congressional district, and that you can have no more than 15% of the voters from any one congressional district. However, the court said that disenfranchises a lot of voters. That disenfranchises, let's say, for example, the 14th Congressional District. It's entirely, I believe, in Wayne County. So that means with Wayne County having something like 1.2 million registered voters, that no more than 15% of the signatures could come from Wayne County. Now, if you think about it, I'm a conservative, more often, identify with the Republican Party than any other. And so for me, any particular things that I would like to see happening or not see happening, I'm not going to probably want a lot of petitions being signed or signatures being gathered that come out of, 1.2 million registered voters signing in Wayne County. However, is that fair and appropriate? Is that constitutional? Does that give the people in Wayne County a voice? Well, no, it doesn't. It's not appropriate under the Constitution. It doesn't give them an equal voice if you're going to say, well, only some of their signatures can count, not the others. So I get the ruling in that regard. Now, what did the legislature do after the state Supreme Court has said, nope, that's not constitutional? Did the legislature clean up that part of the statute? In fact, there are several statutes that were implicated in this. No. If you look up those statutes today at Michigan legislature.gov or whatever the website is, those statutes are still on the books. In fact, you have to look at the note and it says compiler's note, and it'll give you the information that a court case has declared that provision unconstitutional. And you have to do all kinds of looking and digging and figuring out what part is unconstitutional, and it's awful. So the reason why I bring that up, well, number one, I had to encounter that myself when doing the petitions for the Restore Freedom Initiative petition, which we're still getting signatures for, by the way, because what we're doing is trying to stop all of these laws, the 1945, the 1976, all the public health code parts that are terrible. All of these things will be addressed by the Restore Freedom Initiative constitutional amendment petition. With that being said, though, so these laws were left on the books by the legislature. So does that mean that they can still use them? No. Does that mean that any governor can try to utilize them or enforce them, or any attorney general can try to enforce them? No, it doesn't mean that. So when we say the 1945 law has to be repealed, I agree, it absolutely should be repealed. But you would think that every single one of our state reps and every single one of our senators, nearly 150 between the two combined, that they would remember they took an oath of office under Article 11, Section 1 of our state constitution to uphold the U.S. and Michigan constitutions. And both of them have been looking, or all of them, I should say, have been looking towards the Supreme Court to declare for them whether this was constitutional or not. And so since they're all heavily relying on the courts to tell them that the answer to that question, now that the court has answered that question, you think they'd all be equally as willing and eager to go and correct the state of affairs in the legislature and repeal the 1945 law. Are they going to do it? I don't know. But, and is the governor going to veto it or not? Well, think about it this way. The whole point of the 1945 petition was so that if they only get a majority of the votes, just a majority in the House and Senate, and they send it to the governor's desk, and the governor says, no, I'm not going to do anything with that, I'm going to veto that, then it would have to go back to the legislature, and they'd have to get a supermajority, a 2/3 vote, to pass it into law and get rid of the 1945 Act, right? But now, look at the situation. If the legislature puts, the Republican-led legislature, if they put forth a bill that says we're repealing the 1945 law, regardless of the signatures, right? Those don't exist for a minute. They're not all the way through the Secretary of State anyway, right? So even if we assume they're going to have enough, they don't have any officially to that point right now. So let's say the legislature goes ahead and they have a bill to repeal the 1945 law by a simple majority, and then it lands on the governor's desk. The governor has already been told repeatedly now by the Michigan Supreme Court that that law is unconstitutional. They've been told that in the case where she was sued by the legislature. They told her that in the case where the 3 doctors' offices and the 1 patient sued her. She knows. She has zero reason to try to veto that. So do you really think she's going to veto that at that point? She's going to say, yeah, whatever. Okay, I'll sign that. Okay. Got to do what I got to do. But good thing I have all these other laws that are unconstitutional that are still in the books. I get to use those instead. So just keep that in mind, okay? So the focus, do not let them turn our focus to simply repealing the 1945 law. It should be repealed. Yes, it should. But don't let them don't let the media or the legislature or the governor or anybody else draw your attention way over here to think about the 1945 repeal. When we are then ignoring the 1976 law is still a problem, and she can't use it under this scenario right now. But I wonder, what about next year? Is she going to try to claim that it's a whole other new emergency? We need to get that law gone. Is Unlock Michigan going to do a petition to repeal the 1976 law? I'd love to see that. I'd sign it. I want to be the first one to sign it if they do. You know what, though? The 1976 law is not the current problem right now. What is? The Public Health Code. Even if we just look at the two that the Department of Health and Human Services and the local health departments are using, MCL 333.2253 and MCL 333.2453, even if we just look at those two, Unlock Michigan, you've got far more money than I do at Restore Freedom Initiative. You guys have all these, I think, 60,000 volunteers, right? Why don't you guys do something to repeal the public health code provisions that they are now using to try to control us with the same exact measures as before? Please, again, I want to be first in line to sign that repeal petition. In fact, it would do so much to help us right now. I would make sure that the volunteers that believe in what we're doing with Restore Freedom Initiative, that they would know that it behooves us to have that petition in hand as well. And every single event we're at, we would circulate both. Can you imagine? It would be record time. I bet you, if you put together a petition to repeal the public health code, by the time that it went through all the proper channels and procedures, you could have signatures within 30 days. You could have far more than the 340,047 signatures that are needed in less than 30 days. Absolutely. So let's get it done. The thing is, we would also need to know that the legislature would be willing to do their part. If they weren't willing to do their part, then what does that mean? That means that initiative to get rid of the public health code, it's not that it would go away, it's that it would have to wait around for the next general election, which would be November 2022, which is the same election that the Restore Freedom Initiative petition is going to be voted on. So, and that would be part of the Restore Freedom Initiative petition. But you guys, please, Unlock Michigan. If you guys really want to unlock Michigan, let's get it done. Let's get rid of that 1976 law. Let's get rid of the parts of the public health code that are the problem. What about the parts of the public health code where the local health department officers are allowed to, without even knowing your name, without even getting a warrant specific to you as an individual, they are allowed to go and pick you up, transport you to a government facility, observe you, of course, detain you through all this, diagnose you, and treat you for COVID-19 or whatever other horrible thing that they think that you have. They can do that under the public health code right now. In fact, there were, some nameless warrants issued right here in the state of Michigan during this very COVID-19 pandemic under that particular statute. So we have some problems with our laws on the books. The public health code is one of them. It's one of the bigger ones. We have some huge licensing issues. We don't want the, the executive branch to try to just continue to bully businesses into enforcing these kinds of measures when they're not grounded in science, they're not grounded in medicine. In fact, I'm sure a lot of you watching this now know that the World Health Organization came out against these lockdown measures. They are telling communities, they are telling states, they're telling countries, yeah, this is a bad idea. Let's not continue all these lockdown measures. So if you're telling people you can't gather for any purpose, there's a lot of bad stuff that happens with that. Definitely if you're telling people that you have to wear a mask and it's not a choice, there's a lot of bad stuff that can happen with that. But of course, they don't want to make sure there's that proper dialogue and discussion and back and forth information on that. So at any rate, I can go on all day about that. Here's the big deal, right? The main thing. Let's look at just the separation of powers. As the Supreme Court pointed out, let's see here. I'm going to try to find this very specifically for you. So a couple of things I want to point out for you. The governor said in context with all of what's going on. So despite being a government official who takes an oath of office under the Michigan and United States Constitution, and despite being an officer of the court as a licensed attorney here in the state of Michigan and taking that same oath of office, the governor directly lied to the people. She misled the people in Michigan by saying that this ruling, she said this in her recent press release and press conference, this ruling does not mean that the orders I issued violated the law. She actually said that. What I am here to tell you is that that is a bald-faced lie. It is a total lie. She did violate the state constitution with these orders, and the court said she can't rely on the 1945 law because it's unconstitutional, and the court very specifically said she did violate the 1976 law. So when she says that she did not violate state law, that was not accurate at all. In fact, the court said, quote, this is a quote from the court, the governor did not possess the authority under the EMA to renew her declaration of state of emergency or state of disaster based on the COVID-19 pandemic after April 30th, thus violating the state law. I mean, there's no two ways to see that. But even more concerning, like I said, is that the governor, quote, the governor and director, this is out of their own motion, the governor and director seek to ensure that some responsive measures can be placed under alternative executive authority, end quote. That's what they wrote in their motion for the immediate consideration before the Supreme Court. That's what they filed on Monday, October 5th. In fact, the governor told us in social media posts that, quote, the court held the law was unconstitutional, but that ruling doesn't mean all the protections we have will go away. As she says in here, I have additional powers that I will use to protect our families from the virus. Namely, the Department of Health and Human Services will issue epidemic orders to maintain our statewide mask mandate and limitations on gatherings. These are the alternative administrative executive procedures she wanted to put into place. And after explaining how the new MDHHS emergency order, quote, restricting gathering sizes and requiring face coverings in public spaces should sound familiar because that's what we've been doing and we're going to keep doing it, end quote. She also emphasized that, quote, as your governor, I will continue to use every tool at my disposal to combat COVID-19, end quote. So despite the court invalidating all of the governor's COVID-19 executive order mandates, at least since May 1st, that still left, quote, open many avenues for the governor and legislature to work together to address this challenge. Now, this is because this is what the court says, respecting the separation of powers forecloses no substantial outcomes. So it doesn't stop them from still addressing COVID-19 in a constitutional manner. It only requires us to respect along the way one of the most vital of the procedural protections of individual liberty found in our Constitution. So the main and sole purpose, some would argue, of the separation of powers is not just to protect the individual branches from somebody else encroaching upon their turf, it's to protect individual liberty. Because you can't have someone exercising powers of more than one branch of government. Yet, instead of working with the legislature towards this substantive outcome, right, that respects individual liberties, which should be the main underlying thing we're looking at, the governor remains focused on continuing to combat, of course, COVID-19 through unilateral methods that violate various constitutional protections. And if you want to look at the court in the order that came out, in the opinion that came out on October 2nd, you could look at, I want to see here, I think it's page 28, where the court lists a wide variety of different ways that our individual liberties are impacted. So I'm going to skip some of the other legal stuff that might be boring to you. So basically, also of note is that the court said, and this is again in the October 2nd opinion, the responsibility of this court in recognizing the separation of powers is to ensure that the legislature does not exceed its constitutional authority in making the law, either by encroaching upon the powers of another branch or by relinquishing powers to another branch. The legislature's power, and this is written by the Supreme Court on October 2nd, is only to make laws, not to make legislators. So whether it's to empower a local health officer or the director of the Department of Health and Human Services or the governor herself to issue new laws, to write new laws via executive orders, right? And that's what the governor has told us right from the beginning. Wear a mask, it's the law. That's what the Attorney General said. Wear a mask, it's the law. If you don't follow the law, we're going to hit you with misdemeanor citations and, fines and all kinds of other things, right? Well, the law can only be written by the legislature. The legislative branch is the only branch that has the authority to write laws. So instead of course, heeding the instruction of the court in that regard, what did our governor do? She simply shifted her focus away from the 1976 law and the 1945 law, and instead did a 180 and just found, well, I have over here these parts of the public health code. I'll just use these. And these guys work for me, so they'll do what I say. Yeah, we'll just go this route. So here we have to keep in mind too, okay? So even though they've been calling it the law, what is the law in the state of Michigan? And I'm surprised really that the court didn't go over this at all. The law in the state of Michigan, if you look this up, it's in one of our laws. It's MCL 8.8. MCL 8.8 says the law is one of three things in Michigan. Number one, it's a public act of the legislature. We know what that is, right? Number two, it's initiated legislation by the people. So that would be like the 1945 repeal. A law can be a law to take away another law. That's fine. And so if the people initiate that legislation and either the legislature votes to accept it essentially, or it ends up on the 2022 ballot and the people vote to make it, a reality. Either way, that would become initiated legislation from the people. And number three is the only kind of executive order that has the effect of law. And that is Article 5, Section 2 of our state constitution allows the governor to issue executive orders to reorganize the executive branch. But when she does that, she has to give 60 days notice to the legislature so they can essentially veto it. They can disapprove of it if they do not like how she's done that. So those are the only three ways that we have laws here in the state of Michigan. Clearly, they mentioned executive orders, and the kind that they're doing here, or the emergency orders, they're not on that list at all. They're not laws. They don't have the ability to have the force of law because that essentially is saying they are a law, that they're not laws. And so just as the legislature had no authority to, by the Constitution, to make the governor a legislator, It likewise had no constitutional authority to make the director of the Department of Health and Human Services a legislator, or these local health departments legislators. They're not elected officials put in place by the people to create regulation for them. That's not their purpose. So the governor also told us on October 6th that the director is an important part of her administration, and she's very pleased with the action he's taking by issuing these new orders and would anticipate more. So by her own admission, the governor is simply trying to exercise the same legislative powers that through the public health code that she was prohibited by the Constitution from using under the EPGA. So did the court say that the public health code is totally fine and the governor or the director of the Department of Health and Human Services or the local health departments can continue issuing these orders that regulate the people in that way? No, that issue was not even addressed. I read to you the language of these orders. That is not at all a thing. And if you guys, have any question about that at all, that's why I've posted both of these orders from today, as well as the original opinion from Friday, October 2nd, right on the website, restorefreedomkh.com. I'd ask you to print them out, read them, make sure you see what's all in there. Even if you only want to read the majority opinion, which is the first 48 pages of, it is a lot of reading. But even if you only want to read that part of the court's decision that came out on October 2nd, I'm urging you to do so because it's important for you to see what's in there. So with that being said, I do go in and I talk about some of their, in my response here that I filed on Friday, which you can also see there, I talk about how some of these other pieces that they were arguing, the very reasons why they struck down the EPGA also apply and limit the public health code. Quite frankly, I don't think any of those arguments really matter because what it comes down to is something that, with all due respect to the court, they missed the mark on this one big time. And the director of the Department of Health and Human Services missed the mark big time as well. So, well, let me tell you first, before I get there. So the governor and the director of the Department of Health and Human Services both seem to think that these public health code measures allow these these emergency orders. In some places, she's calling them epidemic orders, but it clearly says it's an emergency order. So at any rate, whatever you're calling them, that his version of EOs, that they can be extended indefinitely. Well, they can't even be issued constitutionally in the first place, but whatever. She says they can be issued and extended indefinitely. She says he has epidemic that he can and is using, and I would anticipate more orders, perhaps, in the coming days. He can extend those, and I fully anticipate until we have some comfort that we've gotten our arms around this disease, don't know what that means, that they will be extended. So she says, mask up. That remains the law in Michigan right now through the department's epidemic orders. Those powers were not at issue in the Supreme Court. They are still standing and they will be exercised so long as they need to be. Well, that's kind of scary, quite frankly, on a variety of levels. So obviously, if you've looked at the director's orders, these orders state they are punishable by a misdemeanor 6-month jail term. You can serve up to 6 months in jail and or pay a criminal fine of up to $200 and a civil fine of up to $1,000, as well as summary licensing sanctions, because he ties that with his prior emergency orders. And that's what a summary mean? No due process at all. They just do whatever they're going to do. They strip you of your license. You don't get to have a hearing until after it's all done. And then you can eventually try to fight and get it back, but not really in front of a real court. They're saying it has to be done through administrative hearings. Oh, it's all wonderful. In fact, I want to say they talk about that procedure in one of their briefs that are filed with the court. So you can read that as well. So a couple other things that I wanted to share with you about that, though. So with these orders, the director of the Department of Health and Human Services is severely limiting our right to peaceably assemble, to operate our businesses at normal capacity, and they all require us to wear masks. No, those are the three most basic things, but these orders go far beyond that. There's additional orders that were new orders that were issued on Friday that I didn't see until after I had already filed my brief with the Michigan Supreme Court, or my response with the Michigan Supreme Court. So it's no secret that the governor and the director are trying to blame the legislature and the court for taking away their powers to save us, right? But they are letting their partisan preferences yield nothing but disdain for their oaths of office and of the Constitution in general. The director said last week, in his emergency order, not in the order itself, but he issued a simultaneous press release. It's right on michigan.gov. You can go check it out for yourself. If you want the exact link to it, you can find it at footnote 32 of the response that I filed, which is on our website. At any rate, the director said that his emergency order is lawful under the Michigan Supreme Court's recent decision. That decision rested on something called the non-delegation doctrine, a legal notion never before used to invalidate a Michigan statute. It's a notion, he calls it, and not used to invalidate a federal statute for 85 years. The doctrine has become popular on the anti-government right, and a 4-3 majority has now used it to invalidate a 75-year-old Michigan law. That sounds like a lot of contempt and disdain for not only the court, but quite frankly, the Constitution. And I'm going to tell you why. So, when it comes to the non-delegation doctrine that he talks about, or even the non-delegation doctrine discussion that's happening in the actual opinion that came out on October 2nd, there's something that we need to remember here. The words of the Constitution itself mean what they mean. Whatever they meant back then when it was written is what they mean today. It's our contract. It's the basis upon which we have our very government. So in doing that, in putting that contract in place, our federal government with our U.S. Constitution put into place some provisions. I don't have any of my constitutions in front of me like I normally do, so I'm going to see how I can do this off the top of my head. I want to say Article 1, Article 2, and Article 3 give Congress, or the legislative branch, the president and the judicial branch, in that order, each of their specific authorities. So Article 1 gives Congress the legislative authority to act. Article 2 gives the president all of the executive authorities to act. And Article 3 gives the judicial branch, the Supreme Court, all of the judicial authority to act. I might have mixed those up, but I'm fairly certain that's the order. That's in our U.S. Constitution. If you look in our U.S. Constitution, as far as I can tell, there's no word separation. There's no phrase separation of powers. There's no delegation of powers. There's no specific wording about that. Now, it should be fairly obvious, if all the legislative authority is vested in Congress, that the president should not be able to use any legislative authority ever. I don't care if it's Trump. I don't care if it's Obama. I don't care if it's, the next president of the United States. Doesn't matter to me. The Republican or Democrat wording behind your name doesn't change it. If you're the president of the United States, you get to exercise executive authority, and that's it. And I don't care how many years of precedent come before us on that point. The Constitution is what controls, not the court. But let's beside the point. That is what's in the U.S. Constitution. If you come over to the state constitution, which is what this whole topic is about, that's what these orders are about, that's what this issue is about, that's what the entire thing was before the court on September 9th, the very hearing that I got to argue part of it, and these other 5 attorneys got to argue part of it. We were limited to 2 questions, and it was whether the governor's orders violated state law and whether state law violated the state constitution. So we shouldn't really be looking at the U.S. Constitution to answer those specific questions, necessarily, although they should play a factor if there's a huge violation of the Constitution. We need to always address that. But specifically speaking, technically speaking, we're answering just those two things, right? So if we look at the state constitution, it has the same things that the US Constitution has. Article 4, Section 1, Article 5, Section 1, Article 6, Section 1. In that order, they each give the legislature, the legislative authority, the governor, the executive authority, and then the state Supreme Court, the judicial authority. Okay, Article 4, Section 1, Article 5, Section 1, Article 6, Section 1. And you can also click, I forgot to mention this, I always try to. If you are looking to follow along, I have a copy of the most current version, up-to-date version of our state constitution right on restorefreedomkh.com under resources. And you can also find the US Constitution under resources there. So go ahead and take a look. So with either one of those, if you're looking at those powers of government, it's pretty much the same as what we talked about with the United States Supreme Court. So what's different? Because the court in this case, and quite frankly, all of the discussion with the attorneys has been about the jurisprudence, right? The law, the case law, that phrase is actually written into this order. The case law says this, the case law says that. Well, that's a whole nother, case law should tell you something because judges don't get to make law. They're supposed to enforce and interpret if necessary. So at any rate, what's the big difference between the federal constitution and those cases and the state constitution in those cases? It's huge. It's simple, but it's huge. Article 3, Section 2 of our state constitution. It's actually a specific clause. It's not a doctrine. It's a clause. There's something in our state constitution that literally says the powers of government, the authority of government, I forget the exact wording on that, is divided into 3 separate branches: the legislative, the executive, and the judicial branches of government. And then the second sentence of that, because there's only 2 sentences, the second sentence literally says, no one exercising the powers of one branch shall exercise the powers properly belonging to another branch of government, except as expressly provided in this very state constitution. Period. That's it. So what is a way that any branch of government is allowed in our state constitution to exercise a power properly belonging to another part of state government? Article 5, Section 2, where the governor can issue these executive orders to reorganize parts of the executive branch. There's a specific procedure, but that is the only place that she's allowed to do anything like that. There's no other part in there that says the governor gets to exercise judicial authority or legislative authority. So literally, there is no doctrine. It's not a theory. It's not a notion. He said it was an actual notion, a legal notion, never before used to invalidate a Michigan law. Well, you know what? Shame on the Michigan Supreme Court. The entire time, shame on the Michigan Supreme Court that they have not invalidated any of these unconstitutional laws that have been stacking up for decades on the basis of the non-delegation clause, because that is of a very specific set of words that's put in there. We, the people, put that in there to say you can't exercise the power of one branch of government if you're in another branch of government. That's not how it works here in the state of Michigan. So we have to think about that, because our state constitution, in a variety of ways, in various different topics, is much more specific than the United States Constitution. And think about it. Our United States Constitution was put into place before our state constitution was. So the framers, we, the people of the state of Michigan, when we put together our state constitution, we saw how things had been not quite going right at times, or how government had grown already at that point far too big for its britches. And we decided, you know what? We're going to solve this. We're going to stop these things from happening here in the state of Michigan. We're going to proclaim once and for all, you cannot exercise the powers of one branch of government if you are already exercising the powers of another branch of government. So it is literally complete ignorance or utter disdain for the Constitution itself for our director of the Department of Health and Human Services to go in his press release and on Michigan.gov, in the official capacity of the executive branch, to say that the decision to invalidate the 1945 law rested on something called the non-delegation doctrine, a legal notion never used before in Michigan to invalidate a law. Well, whether it's ever been used before or not doesn't matter. If we're following the Constitution, it could be the first time, it could be the 1000th time. If it's following the Constitution, that's what we're supposed to do, period. Even if we've been violating the Constitution for decades, does that really mean we should continue violating the state constitution? Is that literally your argument, Mr. Gordon, that we should continue violating our state constitution? Because that's what's been happening. That's the cool thing to do. All the cool kids are doing it, so we're going to do it too. No, you took an oath of office. Guess what? He was not an elected official, and he is an official. He's recognized under Article 11, Section 1 of our state constitution. But what about local school employees? What about teachers? What about school bus drivers? What about people that just work at the county health department or the county buildings, or they work for city government? What about them? All those people that were not elected. Even the people that are not even appointed, they're just hired. They're just traditional employees. Well, they didn't take an oath of office, right? Wrong. They did. The law says in MCL 15.151, it's a bunch of ones, a bunch of fives. You can't miss it. 15.151, that if you work for a governmental entity, even if you are not elected or appointed, but simply an employee, a representative of that government entity here in the state of Michigan, that you have to take the exact same oath of office that essentially the Article 6 of our U.S. Constitution, but more specifically Article 11, Section 1 of our state constitution requires, that you have a duty to uphold the U.S. and Michigan constitutions, period. You must uphold the U.S. and Michigan constitutions. So for all of you that have reached out to me that haven't gotten an answer yet, because, well, as you can see, I've been a little busy working on this stuff. I'm not ignoring anybody. If you work for a public school, if you work for the local health department, if you work for the state government in any capacity at all, if you work for the county or the city or a township or a village in any capacity, if you're the janitor, if you are the groundskeeper, if you're just the clerk, if you're the treasurer, it doesn't matter. You have the same oath of office. MCL 15.151 says that you have a duty to uphold the U.S. and Michigan constitutions, period. Not a duty to uphold all the laws in the state, because when the laws of the state violate the state or federal constitution, you shouldn't have to be in a position to choose. No, it says that you have a duty to uphold the U.S. and Michigan constitutions, period, and that you will take no other oath of office in order to have that role. That is exactly what Article 11, Section 1 of our state constitution says. So if you have contacted me, if you have any question at all about whether or not you should or could enforce these emergency epidemic orders, the answer is no. You actually have a constitutional and a legal obligation to not enforce these orders. Absolutely. If there's any question about that, at this point, I honestly don't know what to say. So what about the rest of it? What about these statutes? I've talked about it in some interviews. I was on Justin Barclay's show on Wood Radio last week, and let's see, I want to say it's also something that we talked about on the Fox 17 news interview. I'm trying to think about this. Of course, Micah Young and the 2A EDU, also the Patriot EDU YouTube station. If you guys aren't part of that, make sure you plug into that. The Bob Dutko show, radio show, Charlie Charlie, Charlie, I can't even remember how your last name's missing me right now, but with Let It Rip on Fox 2 in Detroit, that TV station, as well as a subsequent radio interview with him. I mean, however you might have heard me, Steve Gruber, I'm trying to remember, Trucker Randy up north in the Sheboygan area, also on the, oh my goodness, the 3 channels. Hey, Emma, what's that channel that you like up north now? Do you remember? What is it? B1039? Okay, I'm going to take my daughter's word for it. At any rate, you can bring me the jug if you want to, and if you can reach one of them. Anyway, so if you heard me talk about it on there, that's the same discussion I'm going to have right now. I just want to be clear. There's a lot of things going on. I know it can be super confusing. No matter what, this is not a government of attorneys. It's not a government of judges. It's not a government of anything else other than we the people. And we the people of the state of Michigan need to be able to understand the laws and the rules by which they're trying to govern us, because it's we the people who retain ultimate control. We're guaranteed that under Article 4, Section 4 of our United States Constitution. So we the people need to understand these things. We the people have to work together to enforce them and hold our government officials accountable, no matter what level of government they're at. I don't care if the mass media is against me. I don't care if the Republican Party is against me on this. I don't care if the Democrats are all against me. It doesn't matter who's against me, because I'm going to stand for the Michigan Constitution. I'm going to stand for our United States Constitution. I'm going to stand for the truth, because this is the right thing to do. Now, my daughter wanted to make sure we got a plug for the right station. This was one of the 3 up north. It is B103.9. She's very intelligent. I'm glad I have such a smart 6-year-old. Okay, go bring it back, please, baby girl.
Thank you.
Thank you. You need to get your stuff ready for Awana, too, by the way, please. Okay,
Oh.
stuff for Awana. Go get your stuff. Thank you. So with that being said, I want to explain the 3 things that these 2 statutes do. Shoot. I really wish I had my board here so I can explain it to you guys on that. But anyway, okay, so the 3 things, I know a lot of you are visual. I'm going to just try to do that. Do I have anything that I can write on? Here I do. I'm going to grab a Sharpie. Okay, so there's 3 things that these statutes do, right? So this is MCL 333.2253. That's for the state level. And 333.2453. And these are these local health departments. Okay. So hopefully, for those of you who are visual, this will help you out. Okay. I'm sorry I don't have whiteboard behind me today, but there's 3 main things that they're allowed to do. So the first main thing that the law allows them to do is to prohibit, I can't talk and write at the same time, gatherings for any purpose. We're going to come back to that one, because that should be obvious what's going on with that. Number 2, they are allowed to issue orders to ensure continuation of essential public health services. And we're going to go over that in a second. And the third is that they are allowed to issue orders to enforce current health laws. Okay. For those of you who are visual, these are the 3 things that these statutes aim to do. Oh, sorry, those of you over here can't see that. So these 2 statutes are the 2 statutes that the orders that are coming from your, like, Oakland County Health Department or Ingham or Livingston or whichever counties have these local orders. That's this one over here. And then the state orders that the director, Robert Gordon, is issuing, the guy who has total disdain for our Constitution, that's under this statute right here. But they both say identical things. They both allow them to act with 3 things in mind. So 1, they're allowed to supposedly prohibit the gathering of people for any purpose. Okay. They're allowed to ensure the continuation of essential public health services, and they're allowed to enforce current health laws. So let's stick with this one right here. Are there any laws on the books that allow our government to shut us down? Are there any laws on the books that say you have to be as a business at half capacity? Or that as a movie theater, you can't open until October 9th? Are there any laws on the books that say you have to wear a mask in public? Any of those things? No, there's no laws on the books for that. So that, oh, that marker sucks. So that's a no-go. They cannot use that for any of these orders. Well, what about this one right here? To ensure continuation of essential public health services. What is a service? A service, I mean, it's common sense. Let's just use common sense. But if you look it up in the Black's Law Dictionary, it's doing something that's of benefit to someone. It's offering them a service, right? So if I go to a car wash and they want to provide me with a car wash service, it's something that is of benefit to me that I will pay them for or whatever, right? Government services are things that are being offered to us. Essential public health services would be if they want to offer vaccinations, if they want to offer, screenings for STDs, if they want to offer pregnancy tests, if they want to offer even mammograms or ultrasounds during pregnancy, if they want to offer in COVID-19 world, what would that mean? They could offer education on COVID-19 and different ways to avoid the spread of COVID-19, or what to do with your immune system to build it up. They could offer those educational pieces. They could also offer masks. They could offer masks and have them available at different government entities. They could say that every single government place has to have these available to people. Of course, if they're going to tell the local and county agencies, the cities and villages and whatnot, that they have to offer these, they would of course have to provide them financially for that, but that's a whole nother story. So, but they could require that it's an offering to people, that there is a mask available for you to use. They could offer hand sanitizer at all the government places. They could even offer to have little hand sanitizer bottles available for people to come and pick them up from the local health departments, right? That would be a service, that would be continuation of public health services. Quite frankly, the continuation of essential public health services should focus on, is there anger management, opportunities for people that are, say, court ordered or just need help with anger management? What about domestic violence education in general? Or what about, marriage counseling services? What about group therapy for different kinds? What about, things like AA or NA? What about all those different kinds of resources so that people who are struggling with depression or anxiety or, have issues with child abuse and neglect, like parenting education classes, child abuse and neglect cases are skyrocketing during these times. I would say it's one of the arguably most crucial public health services to continue would be to give parents education on how to properly provide for the education of their children, how to provide proper nutrition for their children, how to not get too angry and explode in ways that are inappropriate when your children are home alone with you more than they would be because your school district has shut down because they're afraid of COVID-19. How can you follow through on school assignments with your child when they're not wanting to do Zoom education or whatever the situation is, right? Those are stressful situations. We need to provide continuation of public health services, education, offering support, lifting families up in those situations, not smashing people down with requirements. There is no part of this at all that says ensure continuation of essential public health services. And by the way, put a whole bunch of requirements on people. There's no requirement in this at all. So that's a big no. They cannot require masks. They cannot require you to shut your business down or anything like that. So that's a no-go. What they're doing doesn't fall under either one of these two. So what about this one up here? Well, some of the county's orders and definitely the state orders are trying to prohibit the gathering of people for any purpose. Are they allowed to do that? I would like to think that at home, regardless of your political affiliation, regardless of how much you've studied government at all before, if I ask you that question, you're emphatically going, no, the government can't stop us from gathering for any purpose. We have they have zero right to control us in that way. We have the right to peaceably assemble in, the First Amendment of our United States Constitution, as well as in Article 1, Section 3 of our state constitution. You have the right to peaceably assemble. You also have the right to consult your government, to consult for the common good. That's our state constitution wording. Under both, you have the right to petition your government for a redress of grievances, which oftentimes means holding rallies and making a public statement and gathering signatures and being able to just consult for the common good, decide what needs to be done about a particular situation. We have the right under our Constitution, our state and federal, to do that. You also have the right under our state and federal Constitution to practice your religion freely, right? That's under our First Amendment of our United States Constitution, and we have even more protections under our state constitution. I'm just going to get that out for you guys. Our state constitution says that every person shall be at liberty to worship God according to the dictates of his own conscience. That's what that says. If you go to a church that has 6,000 people and you gather 3 times a week with all 6,000 people and you don't wear a mask because that's part of your religious beliefs, that God wants you to have fellowship and open communication with your brothers and sisters in Christ, or whatever the situation is, if that is how you believe that you are to worship God, then you're allowed to do that. And guess what? The government can't do anything about that because that's in our state constitution, Article 1, our Declaration of Rights, Section 4, freedom of worship and religious belief. And in fact, can they diminish that? What about, this is COVID-19, they can change that. They can reduce that. They can restrict that in some way, can't they? The answer is no, absolutely not. Well, where do I get that from? Look at our preamble of our state constitution. We, the people of the state of Michigan, grateful to Almighty God for the blessings of freedom and earnestly desiring to secure these blessings undiminished to ourselves and our posterity, do hereby ordain and establish this Constitution. So literally all of the other things that flow from that flow from the fact that God gave us our blessings of freedom, and we are going to secure these blessings undiminished to ourselves and us. We're the posterity at this point, right? We're the offspring. We're coming generations later. So that is exactly what our state constitution says. Quite frankly, if you don't like it, I don't care. I don't want to hear about it because I didn't write this. I'm telling you what it says. If you don't like our state constitution, there's a provision in our state constitution that tells you how you can fix it or how you can address it or how you can change it. In fact, the Restore Freedom Initiative here in Michigan is serving to do just that, to clean up any of these, loose ends that are out there, any of these provisions that have been added along the way to muddy up what our constitutionally protected God-given liberties are there for, okay? And so if you'd like to get on board with that, if you'd like to ensure that this public health code doesn't become or stay a problem for us, what about the 1976 law? She's not using it right now, but what about the next governor, or what about next year, or in her next term, heaven forbid? If you want to make sure that you are stopping that, make sure to sign the Restore Freedom Initiative Constitutional Amendment Petition. If you want to make sure that the legislature can never again put into place a law like the 1945 Emergency Powers of Governor Act, then sign the Restore Freedom Initiative Constitutional Amendment Petition, because that is what will stop this. Now, again, if you were tuning in later and you didn't hear me say earlier in this video that I am asking Unlock Michigan to go ahead and truly unlock Michigan, please put together a petition right now to repeal the 1976 law. But most importantly, right now, I'm begging you, Unlock Michigan, please put together a petition to repeal the public health code provisions that give them this authority, which is illegal. Stop this nonsense. The governor and the director of the Department of Health and Human Services keep claiming, well, this isn't the law that they're talking about. We have all the legal authority we need to continue to do this to you. Unlock Michigan. Please help us to unlock Michigan. Do your part in putting together a petition to get rid of MCL 333.2453 and MCL 333.2253. It's the exact same subject. It's almost identical wording in both those statutes. Please help us with that. I want to be the first one to sign that repeal. So please, MCL 333.2453, MCL 333.2253, Unlock Michigan, please get your $1 million of donations put to use there. Get your 60,000 volunteers plus that you have all across the state. Please get them together to do this, because I've been warning everybody since April, this is a problem. It's not just the 1945 law. It's not just the 1976 law. I've been telling people since April, the public health code is a problem, and they are going to use it as a weapon against us. Now, don't forget, if you're going to do those two, just keep in mind, our work would be done for now. It would stop those orders. But we would still have to clean things up. We would still have to make sure we get this constitutional amendment passed, because we still have laws out there, such as another part of the public health code. I want to say might be 325-5207 or maybe 333.5207, something like that, where they are allowed to pick you up off the side of the street if you exhibit any of the symptoms of COVID-19, which are also the same symptoms as the flu and just honestly being run down, being overworked and tired. If you have any of those symptoms and they have reason to believe that you might have COVID-19, that law on the books allows them, this other law on the books in the public health code allows them to pull you off the street, to pick you up, to detain you, to transport you, to be able to observe you, and to diagnose you and treat you up to 6 days without you ever even setting foot in a courtroom, to have your arguments in front of the court about why you should be let out. They can supposedly do all of this to you for up to 6 days. That's awful. Do you guys want that to happen to you? If you just walk around looking like you're tired, or you say you have a muscle ache, or you have a cough, or if maybe you just came from the gym, you were exercising, and now you have a little bit of a fever, your temperature is up, and they think that you look a little flush in your cheeks. Literally, the wording of the statute allows them to scoop you up, throw you into some facility, and to observe you and diagnose you and treat you. Now, what does that mean? They can treat you however they think that you need to be treated. Apparently, they don't think the hydroxychloroquine is an appropriate remedy. Apparently, they don't think you should have vitamin C or B12 or vitamin D or any of those things. They're not going to let you just be outside and get fresh air and all that, because they don't think that's what treats COVID-19. So please make sure to realize that we need to get these acts repealed, sure, but then there's always more. There are more tools, and that's what the governor is telling us. She has plenty of these tools at her disposal, and she's going to keep using them. So please, guys, please realize that even if we win on one of these laws, the fight is not over. Do not turn a blind eye to this. We are nowhere near done. We still need to work together. We still need to fight for our freedom and tell them who's boss. And who's the boss? We the people of the state of Michigan, we the people of the United States, we are the ones that hold the power here, not the governor, not the director of the Department of Health and Human Services, quite frankly, not the state Supreme Court, not the United States Supreme Court, regardless of who gets in office, if Trump's nominee gets in or not. The United States Supreme Court is not the final arbiter of our rights here in Michigan or in the United States. God gave us our freedom. God gave us our freedom, whether you believe it or not. It's written in our Constitution. If you don't like it, take it up with the framers, not with me. God gave us our freedom, and we have a duty to enforce the Constitution as it's written. In fact, if you took an oath of office, you took the oath to uphold the U.S. and Michigan constitutions as they're written, as they're currently in force, until the people have decided to change it. You know, it's really strange. I'm seeing a lot of angry faces. I guess people that are watching don't like the Constitution. You can go to another country if you don't like the constitutions we have here. You could submit petitions to try to change the Constitution if you don't like them, but you have to follow them. In fact, we each have rights that are not even enumerated. We didn't even go with that. The non-enumerated rights, we have those in Article 9, Ninth Amendment of our U.S. Constitution, Article 1, Section 23 of our state constitution. We have rights to breathe fresh air. We have rights to just have a family. We have rights that we don't need to put down in a list and prove to somebody that we have a right to do. That's what the whole point of unenumerated rights that can be exercised undiminished, and that the government has the authority and the duty and the obligation to protect those rights. If you're in government and you don't believe in any of this, then you're violating your oath of office and you need to get out of your office. You need to vacate it. You just resign right now because that's what you signed on for. And if you forgot about that, or you didn't realize that, or your opinion changed as time has gone on, you need to just step away from that role because you are no longer worthy of that office. You are violating your oath of office if you're not willing to uphold the U.S. or Michigan constitutions. So if we conclude that point right there, you cannot prohibit people from gathering for any reason. The law says you can. The Constitution says you can't. Now, what trumps? The law or the Constitution? The Constitution every time. I mean, you can look at the Supremacy Clause of the United States Constitution. That's in Article 6 of our state constitution. You can look at the case of Marbury versus Madison in the 1800s that describes what that Article 6 really means. But the Constitution is the very contract that our government was founded upon. And so if you have a state law that is passed, a city ordinance or an executive order or an emergency order by a director of Department of Health and Human Services that violates that very Constitution, it's not enforceable as a matter of law. It's void. It's as though it didn't even ever exist in the first place. So are the orders enforceable? Are they, the new ones, are they allowed to require us to wear masks? Are they allowed to require our businesses to maintain a half capacity or less? Are they allowed to prohibit us from gathering in any number at all for any reason? No, no, no. So if you don't believe me, look at these statutes. They're not very long. They're not very long at all. I ask you to read them for yourself because we are not a government of attorneys. So read these for yourself. Figure out if you see these three things that they're allowed to do, and if you see how requiring people to wear masks doesn't fit in any of these. Requiring businesses to have half capacity doesn't fit in any of these. And any kind of way of limiting the people from gathering is not constitutional in the slightest. So if you're not going to read the whole Constitution tonight, I'm going to beg you, please read Article 1 of our state constitution. And please read the first 14 amendments of our United States Constitution. Just read those parts tonight. Read them to your kids. Read them to your spouse. Read them for yourself. Even if you've read them 300 times before, read them again because you're going to pick up something that you didn't quite pick up on before. That is when God speaks in Romans 13, and he's talking about that we have the duty to follow the governing authority. The governing authority here in the United States is we the people. And we're bound by the Constitution that we basically all signed on to, right? We had people representing us. We came together and we said, this is the manner in which that we want to have our government and operate our government. So we're going to do it this way. And we're going to follow these rules. And by so doing, we're going to live together in society where we're each going to be able to exercise our own individual liberties that God gave us. God did not give the country liberties, right? We as a people did not come together to give our community liberties. We did not give our state liberties. We did not give our counties or our county boards or our governor certain liberties. It's we the people, the individual people that have liberties, and our government has the duty to enforce protections of those liberties, period. So with that being said, there is an insane amount of comments on both of these. Okay, and I see Lori's trying to get people to come over here. I'm going to tell you what. Because we have the right to, I'm going to read that exact wording for you guys again. You better have all of your Awana stuff ready to go. Because every person shall be at liberty to worship God according to the dictates of his own conscience, I'm going to exercise that religious liberty that is given to me under Article 1, Section 4 of our state constitution. And I'm going to someone's house right now to study about God and to have fellowship with fellow Christians. This is not the hair salon, girlfriend. You got to move it on. Move on. All right. So because of that, I have to be there in 6 minutes and I will have to take off for now. But I will definitely look up these. In fact, if enough, you guys stop, baby. It's shaking the table. Thank you. Okay. Okay. So right now I'm not even seeing a bunch of questions. So what I would say is, if somebody would like to get questions, don't send them to me this time. Last time I had people do that, and that was amazing. I'm now getting well over 200-300 emails every single day, and I would never see the questions. So I'm going to volunteer my amazing social media woman, Lori. She's going to want to shoot me. Restore Freedom Events. Okay, good. I have someone telling me I got a few minutes to my meeting. restorefreedomevents@gmail.com. If somebody wanted to collect these, summarize them, I can address these in a follow-up video for you guys. Maybe tomorrow. I honestly don't even know what kinds of things I had on my calendar that I didn't get to because these orders came out and I wanted to make sure you guys knew about them right away. So those of you that are watching on the Facebook Live or that will watch later on the Facebook Live, I'm not going to answer any questions on there because I'm going to try to get people to go towards the YouTube channel. So if you have questions for me, head over to YouTube as quickly as you can because I'm going to ask somebody in the audience to go ahead and summarize the questions that are out there that did not already get answered. Okay, so if they're already answered in the video, please do me a favor and don't have those questions in there. But if you want to give those summaries over to Lori, all right, Lori, she doesn't hate me too bad. She put it right in there, restorefreedomevents@gmail.com. So thank you very much, Lori, for that. So again, Lori will make sure that I get those and I'll be able to answer those in another live. Again, my Facebook friends, we know what Facebook has been doing. We know Facebook has been shutting people down left and right. I don't want to rely on Facebook. Facebook is not a friend of mine anyway. I don't have Facebook Messenger. I haven't had Facebook Messenger working since May. So for those of you trying to contact me through Facebook, I'm going to ask you, please try to move your communications elsewhere. Please try to reach one of our team through our emails. You can go to our website. The Contact Us page will steer you in all kinds of ways specific to your need or your request. If you're looking just for general information or updates, our website, the resources tab is going to be fabulous for you. Obviously, our YouTube channel is where all of our videos end up anyway. I'm going to start doing more and more of those live there. So guys, if you're watching me already on YouTube, please go ahead and hit the subscribe button. And there should be, I've been told, I can't see it from my end, a little bell or something so that you can press that and it'll give you a notification when I do go live again, or I believe even if I schedule one. So you'll be able to see that and know ahead of time and be able to come on board at the beginning instead of, you know, getting the notification or just happening to come across it later on. So again, Facebook friends, a lot of those things that we like about Facebook, you can actually do through YouTube. So please come on board to the YouTube channel and find us there. I believe it's been kind of put in there several times. But please, again, any questions you have there, please come on board over here with YouTube so I can answer them that way. I don't want to have everybody put all their questions in Facebook and then all of a sudden I'm the next casualty of Facebook war and I can't see anything and you guys can't hear any answers from me, right? So let's go ahead and go over to YouTube for now. And again, I will get these. Ooh, I do see one question, but I'm going to answer those at another time. Like I said, get your questions on there, and I'm going to ask for one volunteer to go ahead and summarize all those and get those over to Lori. I've got her on about 12 other projects right now, so she can't be the one to summarize these questions, but she will make sure to get them over to me. Thank you so much, guys, everyone. And please remember, All this is scary. All of it's terrible and horrible, and we're losing, relationships and family members and friends over this. And there's a lot that's going on. We have our jobs on the line if we're, not willing to, violate the Constitution or those kinds of things. So, parting words. For God hath not given us a spirit of fear, but of power, of love, and of a sound mind. 2 Timothy chapter 1, verse 7. Please make sure you keep that in mind. We don't have a spirit of fear. He didn't give us the spirit of fear. He gave us a spirit of power and of love and of a sound mind. So with that being said, I'm going to sign out tonight, everyone. Thank you so much for tuning in today, and I will give you more information as it comes to me. Thanks, everyone.